All right, so next slide. So first, a little bit of background about NYLAG. New York Legal Assistance Group is started in 1990, and the Evelyn Frank Legal Resources Program focuses on older adults and people with disabilities. We do direct representation. We do a lot of training like this one. We represent people, and we also advocate. And we advocated to repeal these restrictions, but unfortunately that was unsuccessful. Next slide. On our website, which is a little confusing because it's not on the NYLAG website, it's nyhealthaccess.org. And there's a lot of information there, including a news article about these changes. And Rachel will post a link to that. Next slide. So today, our plan is to give some background. This was one of three changes enacted in 2020 about Medicaid home care. And we'll just talk a little bit about both of them, look back, ADLs, and there was a third one that's not even on this list, but we will also be talking about this. And then we're really going to dig into what is starting September 1st, the requirement that a person be determined to need assistance with 3 activities of daily living. So we will really get into that. What are these new limits? Who decides whether someone meets these requirements? And that's a focus on the different pathways to home care and what entity will do the new ADL test. Then I know everybody's very interested in knowing who is grandfathered in. They're using a new term for that called legacy status. And a lot of your clients will be grandfathered into the old criteria. But unfortunately, new people apply for home care all the time, and they will not be grandfathered in. So we will be focusing then on what steps will they take, what appeal rights do they have if they are denied home care because of these restrictions, and we'll give some tips on doing these assessments after September 1st. Finally, we'll go into a little bit about, are the ADL limits legal? And are they smart? And then where to go for help. And please support us. A link to donate to support NYLAG, making it possible to do free trainings like this. Next slide, please. So as I mentioned, in 2020, the former governor, Andrew Cuomo, enacted several Medicaid cuts. And this was just when COVID started, and the state was looking at a huge fiscal crisis because it was before Congress passed all of the relief that flowed to states to support their Medicaid programs through COVID. So 2 of these cuts were put on hold that were enacted at that time. This one, the 3 ADL threshold for all home care, which we're focusing on today. Another one is the 30-month look back for home care and the assisted living program. We will not be talking about that today because that has no implementation date yet. Now, there's a third one called the New York Independent Assessor, and that has been implemented, and we'll be talking a lot about that. That was not put on hold during COVID. So the 3 ADL rule and the 30-month look back were put on hold because when Congress gave billions of dollars to states, they were not allowed to restrict eligibility for Medicaid. And until the public health emergency was over, and then when the way they spent all these billions of dollars was approved. So CMS approved the state's expenditures in early 2025. We didn't hear about it till recently because they didn't post it anywhere. But we heard about it from the state when the state sent out these directives starting the 3 ADL limit September 1st. And we asked the state, wait a minute, CMS hasn't approved it yet. And they said, yes, they did. So that's where we are. Now, the 30-month look back is not being started yet because, and we'll talk a little bit about why. So these cuts are called the Medicaid Redesign Team 2 or MRT 2. That's when you hear those acronyms, that's what that's referring to. All right, next slide, please. So just a bit about the look back, because I know everyone's always very interested in that. So the 30-month look back, when it starts, anyone who's applying for Medicaid in order to enroll in an MLTC plan or a MAP plan, or anyone seeking personal care or consumer-directed assistance, which I'll call CDPAP, or anyone looking to enter a Medicaid assisted living program facility will have to show 30 months of financials, and if they made transfers during those 30 months, there could be a transfer penalty imposed, which would delay Medicaid's coverage of the of those services. And there are exceptions, just like there are for the nursing home transfer penalty, the same exceptions apply. We're not going into that now because there are many steps that have to be done. The state has not yet submitted a state plan amendment, sometimes abbreviated as a SPA, which has to be submitted and approved, and there's an opportunity for public comment on that when they submit it. So that will take some time. But our estimate is that it can't be done this year. It couldn't be done before 2026, but we don't have a date. Everyone always wants to know the date, and we don't have one. We just don't see how the state could take those steps any sooner than another year. Next slide, please. And this is the one that we're focusing on today. So the bare bones of this is that there's a new restriction for eligibility for personal care, abbreviated throughout this presentation as PCS, consumer-directed assistance, which known as CDPAP, enrolling in an MLTC plan, and enrolling in a Medicaid Advantage Plus plan. That's a mouthful, often abbreviated as a MAP plan, unless one needs limited physical assistance with 3 or more ADLs, activities of daily living, and we will dig into what that means. Or if someone has dementia or Alzheimer's disease, they can qualify for those services if they need queuing or supervisory assistance with 2 or more ADLs. If this is documented and they have by their physician. So there's paperwork. And so as a result of this, there'll be many people who will not qualify for MLTC. There'll be many people seeking standalone personal care or CDPAP from a managed care plan or from their local Department of Social Services. And it eliminates the standalone housekeeping service that until now, for as long as I've been doing home care, which is over 30 years, if one didn't have any need for assistance with an ADL, an activity of daily living, but one had a disability, one could still get assistance with housekeeping services. And we'll talk more about that, but that is over. that will end, except for people who are grandfathered in. The sites are here for those who like to look at the actual law. And this is starting September 1st. People who already have these services and those in the pipeline will be grandfathered in, have legacy status, and we'll talk much more about that later. This new test does not apply to PACE, which is a small program, sort of like a type of integrated plan that integrates Medicare and Medicaid. It includes all MLTC services, but the enrollment is very low compared to regular MLTC and compared to MAP or Medicaid Advantage Plus. Next slide, please. So the state issued a bunch of guidance around June 30th, and these are the links. If you like to look at the guidance, this webinar will summarize a lot of it, and this also tells you where you can find it online. Next slide, please. So here's the meat and potatoes. When the standard refers to the type of assistance that a person needs with an activity of daily living. So, and the type of assistance is scored on a continuum from 1 to 7 by a nurse doing a home care assessment. And if someone is scored as independent with an ADL, forget it. That won't, of course, that never did satisfy any requirements. If someone was scored as independent, set up help only, so that, say, someone doesn't need assistance with feeding, but they need their plate put in front of them and the fork and a glass of water, that doesn't count. I guess they don't care. They just assume someone's around to set things up for them. That doesn't count, and that never counted. But the third score is what's the big change. The third type of assistance is supervision, which is considered oversight or cueing assistance. So it used to be, until now, until September 1st, that if a nurse scored an individual as needing that type of assistance, supervisory assistance, with just one ADL, they would qualify to enroll in an MLTC plan, and they would qualify for personal care or CDPAP. That is ending. If someone only needs supervision or oversight or cueing with ADLs, they must need it with 2 ADLs, and that will only qualify them if they have a diagnosis of dementia or Alzheimer's disease, and a doctor has certified that. So that is the one of the big changes. Not and that you need 2 ADLs with supervision, and that's only for people with dementia. So there are many other types of diseases and chronic conditions for which people need supervision. It doesn't matter. They will only approve these services if they have a diagnosis of dementia or Alzheimer's. We'll talk more about all of this. Number 4 on the continuum is what they call limited assistance, which is defined as guided maneuvering of limbs and physical guidance without taking weight. So now this is the new minimum. In order to qualify for MLTC, MAP, or home care from the local DSS or from a managed care plan, one must need at least that level of assistance with 3 activities of daily living. From reading the guidance, This should include contact guarding, which is a term used in rehabilitation and nursing, where an individual, like an aide or a family member, is hovering close by the person. So the important thing here is that it's not weight bearing, but it's still physical guidance. Now, there are three higher levels of assistance: extensive assistance, maximum assistance, or total dependence. Any of those will qualify if someone has at least 3 ADLs with limited assistance or higher. Then, regardless of what disability or diagnosis the person has, they will qualify. But so what is now no longer counted is supervision, oversight, and cueing. That no longer counts unless someone has dementia or Alzheimer's disease. All right, next slide. So when we talk about activities of daily living, what are we talking about? Well, the state regulation that implements the 2020 law says we're defining ADLs as those activities recognized as activities of daily living by the evidence-based validated assessment tool. So that tool is sometimes called the UAS, for the Uniform Assessment System, that the state adopted many years ago, at least 10, maybe 15 years ago, as the assessment tool used by all plans, used by DSS, and now used by the New York Independent Assessor. And sometimes it's called the CHA for Community Health Assessment, but they're all the same. And it's the same uniform tool. And looking at that tool, we found that it lists 10 ADLs. So it's, bathing, personal hygiene. Dressing is broken down upper body and lower body as 2 ADLs. Walking on the same floor indoors, locomotion, how one moves locations on the same floors, transferring on and off a toilet, actually using a toilet or commode, or incontinence supplies, bed mobility, that's turning and positioning, and eating. Now, we only have this definition in the regulation. When you look at all their different assessment tools, we're a little afraid that one of the summary tools seems to condense this list of 10 down to 6 or 7. And if they do, that would be bad because it would be harder to get up to 2 or 3 ADLs. But I think that that would violate the state's own regulation because their regulation refers to the assessment tool, which has this list of 10 ADLs. Excuse me. So now putting those things together, now starting, if someone's assessed after September 1st, they must need that limited assistance, which we looked at the earlier slide, with 3 of these ADLs, or someone with dementia or Alzheimer's disease must need supervision or oversight and cueing with 2 ADLs. Now, that's a big change. As I said before, the current criteria until September 1st is that one only needs to have assistance with 1 ADL to qualify for personal care, CDPAP, or to enroll in an MLTC or MAP plan. So that's a big change. So that's our, bread and butter here. These are the concepts that you really need to know. Okay, now we're going to build on that. Next slide, please. So you might ask, well, there are a lot of other tasks that people with disabilities need help with. In the state regulations, they're called housekeeping tasks. Nationally, they're called instrumental ADLs, instrumental activities of daily living. These are things like preparing meals and cleaning up, doing housework, helping people on stairs, which for some reason is classified as an instrumental ADL on the state's assessment tool. Traveling by public transportation, doing laundry, shopping, using a phone, and managing medications. This list is based on the state's assessment tool. That's what they consider instrumental activities of daily living. Well, unfortunately, even if someone needs help with every one of these because of their disability, these do not count at all for eligibility for MLTC enrollment or for personal care or CDPAP separately. You do get help with these if you meet the ADL test. So if you meet the ADL test, then the aid will be then your need for assistance with these IADLs, the instrumental ADLs, will be assessed. And in the plan of care, the aid should be tasked with helping you with any of these tasks that you need help with. But if you don't meet that 3 ADL test, no standalone assistance with these housekeeping or IADL tasks will be available. Now, this is a big change because until now, first of all, you only needed 1 ADL to get personal care and CDPAP or MLTC. And then if you needed that, help with all the IADLs came with it, bundled. And before September 1st, let's say you didn't need any ADL assistance, you were independent, but you did need help with these IADLs because of disability. So under state law, you could get up to 8 hours a week of personal care or CDPAP through the local district, or if you were in a mainstream managed care plan. You would not enroll in MLTC because you wouldn't be eligible for MLTC before because you needed the 1 ADL. But if you didn't have that, you could at least get 8 hours a week, but no more. People who are now getting that service will be grandfathered in. They will have legacy status. And those, any new applicants who fail the ADL test will not be eligible for these 8 hours a week of assistance with housekeeping. So that's a huge, huge cut. Next slide, please. So let's just do some level setting here. Because people come to Medicaid home care in New York through different pathways. And some of you only help people with one pathway, maybe getting MLTC, but some of you might help people getting it through other pathways. So we want to make sure everyone understands how the new ADL test will work through these different pathways. Next slide. Okay, so first of all, everyone has to apply for Medicaid and be determined financially eligible. That's slide 1. And some people apply on New York State of Health because they don't have Medicare and they're under 65 and they don't have other insurance. And some apply at their local district, like the people who are older or disabled. Step 2 is then if someone needs home care, someone who applied for Medicaid, let's say they have Medicare, they then go to the NYIAP, the New York Independent Assessment Program, and that's what determines them eligible for MLTC enrollment, for personal care or CDPAP through different pathways. So now it's that assessor, that NYIAP, that will determine if someone passes the ADL test. So if they do, they then go on to step 3 and services are authorized. So if they're a senior or person with Medicare, they'll enroll in an MLTC and that authorizes the home care. But many people are not do not have Medicare but still need home care, and they might get their home care through their local DSS, like HRA, or they might be in a managed care plan. So I skipped that little off of the first box. There are people, if they, once they're determined eligible for Medicaid, if they don't have Medicare or other health insurance, then they are required to enroll in a mainstream managed care plan. Now, many people who work with older adults and people with disabilities don't have no experience with these mainstream plans because their clients are, and many of NYLAG's clients are disqualified from those plans because they have Medicare. But millions of people in New York do not have Medicare. And so they enroll in that bottom, that arrow from box 1, they enroll in a mainstream plan, and then they go back to box 2 to be determined through the New York Independent Assessor or NYIAP for home care. And that's where they have to pass the ADL test. Now notice that at the top of the slide in red, these are the steps for Medicaid home care for adults age 18 and over. Children do not go through this pathway. They do not go through the New York Independent Assessor. And let's go to the next slide and see what happens for them. So this New York Independent Assessor or NYIAP, this was the other MRT2 cut enacted in 2020, but it did go ahead, and the independent assessor is the gatekeeper for all adults who are seeking to access personal care, CDPAP, MLTC, and MAP, but not for children under 18. They are assessed by their managed care plan if they're in one, or they apply at their local Department of Social Services, and it's that plan or DSS that will now apply the 3 ADL test. Now, there's complicated rules about which children must be in a managed care plan and which ones have the option to go through their Department of Social Services. One of the more common exceptions is that children in the OPWDD waiver have a choice. They may enroll in a managed care plan, or they can choose to get home care through their local DSS. I'm not going through all the exceptions right now. So the independent assessor is run by a private company called Maximus under a contract with the State Department of Health. And it's that nurse, the NYIAP nurse, that conducts that main assessment. We call the CHA or the UAS. It's either in person or by telehealth. A second assessment is done by Maximus called a practitioner assessment. That is always done by telehealth. I've never heard that done in person, but I could be wrong. And that's by a nurse practitioner or a physician's assistant. And then NYIAP decides the outcome of the assessments. They determine, are you eligible for MLTC or Medicaid Advantage Plus plan? Or if someone is in a mainstream managed care plan, they decide if they're eligible for personal care or CDPAP, or many elder law practitioners apply to the local DSS for immediate need services, and those also go through NYIAP. And other people go through the local DSS because they're exempt or excluded from MLTC or MAP. And they also have to go through NYIAP before the local DSS can authorize services. So now that's all been true for several years. But now the independent assessor will also decide if you pass the new ADL test for everyone except children under 18. We have an article about the independent assessor online, and that's the link. And the state has several websites with limited information about NYIAP. Next slide, please. So this is, more level setting, getting into the weeds a little bit. Many of us who work primarily with older adults and people with disabilities think everybody gets MLTC and MAP, but not everyone does. I mean, it's mandatory for someone on Medicare to enroll in an MLTC, MAP, or PACE plan if they want community-based long-term care. And that's personal care, CDPAP, private duty nursing, and adult day health care. You can't get those fee-for-service anymore if you are in that mandatory group. But there are exceptions. If someone is enrolled in home hospice, if someone is in one of the waivers like OPWDD waiver for people with IDD, the traumatic brain injury waiver, and the nursing home transition and diversion waiver, they are either exempt or excluded. Well, they're all excluded from MLTC, so they get their services from the local DSS, but they still go through NYIAP. Then there are people who don't have Medicaid. In the second column, the voluntary column, they're only 18 to 20 and they have Medicare. They may enroll in MLTC, but they could decide, no, I'd like to go to the local DSS. Same thing with people who are not dual eligibles. They have Medicaid only. If they're 18 and over, they have a choice. They may enroll. Now, the box under that in the second column says they can only enroll in MLTC if they're determined to need a nursing home level of care. And that is done through a formula using that UAS tool. When you take the time to look at one of these 20-page UAS printouts, you'll see fine print towards the end of NFLOC score, which is the nursing facility level of care. And if that is a 5 or more, that means the person has a nursing home level of care. So these voluntary populations are eligible to enroll in MLTC. So, we're showing this just because not everybody goes through the same pathway. But the new ADL test will apply regardless of which pathway you go through, whether you're assessed by New York Independent Assessor or even for children who are not assessed by an independent assessor. And those under 18 gets their services either from their mainstream plan or the local Department of Social Services. Either way, they will now have to pass the new ADL test. Next slide, please. All right, so now this is what everybody wants to know. Is my client grandfathered in under the old rules? Do they have to worry about this? This is known as legacy status, and the next slides will review that. So next slide, please. So the first group who are grandfathered in, they call it legacy status, is anyone who is actually enrolled in an MLTC plan or a MAP plan, a Medicaid Advantage Plus plan, or a PACE plan before September 1st, or receiving personal care or CDPAP from a mainstream managed care plan or the local Department of Social Services before September 1st. So those are people who are getting services now. But not, block 2 is about people are grandfathered in if they're in the pipeline. So they don't necessarily have to be enrolled in a plan September 1st to have legacy status. They must have been assessed by NYIAP, an independent assessor, since August 31st, 2024. And they must enroll in an MLTC plan or be authorized for standalone services, personal care or CDPAP, by a mainstream managed care plan or DSS within 1 year of assessment. So many of you have clients who were assessed by NYIA, say last month, July. And we know it takes a long time to enroll in a plan. And let's say they just don't make it by September 1st. So those people would be protected because they were assessed since August 31st. And as long as they enroll within 1 year of their assessment, they will be protected and have legacy status. So there are even some, so now that we're really close to September 1st, the state anticipated a few situations where someone could be assessed after September 1st and still have legacy status. So that's on the next slide. So these probably are rare, but this is the time. We're right now, September 26th. So let's say the client was assessed before September 1st, but it wasn't a good assessment, and the plan or the local Department of Social Services requests a variance. A variance is a do-over, which is just a repeat nurse assessment, and it's all in the guidance that establishes the independent assessor program. So variances are very rare. It's very rare for plans to request them. They're mostly requested by departments of social services, but they're rare. So if they did request a variance and the do-over occurs after September 1st, then they would have legacy status. So if that assessment shows they only have one ADL, they should still be accepted for MLTC or accepted into personal care or CDPAP under the old rules. Another situation is, let's say the client's assessment with NYIA was scheduled for today, August 26th, and it had to be rescheduled, and it's not going to be done until after September 1st. So they will give that person legacy status under very tight requirements. It must be literally the rescheduling date must be set before the date of the initial appointment. So if the assessment was today, August 26th, the consumer or their family had to have called NYIAP yesterday or before and say, please reschedule it. I can't be there. I'm sick and I need to be there for the assessment with my mom. Okay. The need to reschedule must be through no fault of the consumer. Now, that's not defined. We don't know what it means. But those are the two exceptions. And now that we're running up to September 1st, it's something to think about when if you get a client and they lose they're denied by NYIA saying you are not eligible for under the 3 ADL test, double check to see if they might squeeze in under these exceptions. All right, next slide. So you want to make sure your client is grandfathered. So of course, the tip is to get assessed by NYIAP before September 1st. We gave a version of this presentation a month ago, and that was more meaningful than now. There's very few days left, so that isn't so practical. The NYIAP assessment is good for a year. So if the client comes to you and they ask them if they were assessed sometime in the last year. They may have been assessed, and people have a hard time navigating the system. Maybe a plan turned them down because they didn't like the assessment, or they said they weren't eligible, even though that really isn't true if NYIAP found them eligible. But if you can find out if they were assessed sometime since September 1st, 2024, and then they enroll within 1 year of that, they are grandfathered in. All right, next slide, please. So it gets a little more complicated. It's Medicaid, right? So legacy status means that the one ADL rule applies. But there are two types of legacy status. One is plan legacy status, that you are grandfathered under this one ADL eligibility rule for enrollment in an MLTC plan or a MAP plan. There's service legacy status, and that means you're grandfathered under the one ADL eligibility rules for the services of personal care or CDPAP. So someone who's not in a plan, say, who are getting services from HRA, for example, and they've been getting because they're in home hospice or they're in OPWDD, they get service legacy status. They will never have plan legacy status because they're not in a plan. But we're going to talk about some instances where someone might have both types of legacy status. So the beauty of legacy status is that when you are reassessed every year for home care, as everyone is, they are assessed under the old, less restrictive one ADL criteria. They need one ADL to qualify for MLTC or MAP or personal care or CDPAP, and with any level of need, queuing or supervision is fine. So if you have legacy status, can you lose it? And yes, you can. So next slide, please. So for plan legacy status, they are saying that you must be continuously enrolled in an MLTC plan, a MAP plan, or a PACE plan. You don't have to be enrolled in a particular plan. It's fine if you change plans. Let's say you're in Fidelis and the home care agency no longer contracts with Fidelis. They only contract with Emblem Health, and the client wants to keep her aide, so she switches to Emblem Health. As long as there's no gap in enrollment between the changes, you're considered continuously enrolled. And we're saying PACE here, even though the ADL test does not apply to PACE, because the state guidance says, well, someone in PACE might want to change to a standalone MLTC or a MAP plan. So if they're in PACE, that counts for legacy status as long as there's no gap. But here's a big warning. there are reasons why someone might have a gap in enrollment in an MLTC plan. And the state issued guidance last year, now that COVID is over, allowing plans to involuntarily disenroll members for a whole list of many reasons. And we have an article on the website, Can My MLTC Plan Kick Me Out? And that goes through this involuntary disenrollment guidance. So just a few examples are, let's say the client moves from New York City to Westchester to be closer to family. And there's always a delay in getting Medicaid moved to a different county, switching from one MLTC plan to another that works in that region. It looks like they can lose their legacy status if that happens. Or people who are in a nursing home for more than 3 months and have been determined eligible for institutional Medicaid after the 5-year look back are disenrolled from their MLTC plan. And let's say they later want to enroll again. That gap could mean they lose their legacy status. Or this is a big concern now with the CDPAP transition to the single FI. People who, if you're in an MLTC or a MAP plan, and you have not received personal care or CDPAP for a 30-day period, you can be disenrolled from that plan. So now that the NGESR settlement is tentatively approved, and people are, the last people who didn't enroll may not have enrolled. They can be, I'm not sure if it's now, but soon, they can be disenrolled from their plans because they didn't switch to PPL and they haven't gotten any CDPAP services for 30 days. So if they then seek to enroll again in MLTC, they'll have a gap. They will have lost their legacy status. Next slide, please. But there's hope for them, okay? And this is so confusing. There's also service legacy status. So you have service legacy status if you were initially authorized for personal care or CDPAP before September 1st of this year, or were assessed by NYIAP, the independent assessor, in the last year since August 1st. I think that should have been September 1st, 24. I'm sorry, I think that's a typo. And started services within a year. The service legacy status remains intact even if you lose plan legacy status because you have a gap in MLTC enrollment. So because the statute that enacts the 3 ADLs is just a little bit more generous in defining the grandfather provision for personal care and CDPAP compared to MLTC. The statute says if you received or were initially authorized for services before the effective date, you're grandfathered in. So the state has not said how. So let me just go back. If you were in an MLTC plan before September 1st, getting personal care or CDPAP, then you're disenrolled for any of the reasons on the previous slide, you'd lose your plan legacy status, but you still have service legacy status. So to me, that means you still qualify for personal care or CDPAP under the old standards. But the guidance says that fact, but does not say how you would go about receiving your personal care or CDPAP. It seems to me if you're not eligible for MLTC anymore because you've lost your plan legacy status, you should be able to go to your local DSS, HRA in New York City and say, hey, you have to give me my personal care and CDPAP. But that's an inference from this guidance, and the state has not explained that. The same thing can come up for mainstream managed care members who are receiving CDPAP or personal care. One day they become enrolled in Medicare and they are disenrolled from their mainstream plan, which those plans were really not designed for people with Medicare. And people with Medicare stayed in those plans during the COVID public health emergency, but that has ended and now they're being disenrolled and sent to an MLTC plan. But how will they be able to enroll in an MLTC plan after September 1st if they failed the ADL test? They should have service legacy status. So that means they're entitled to the services. But how will they get it? So these questions are not rhetorical. They are real questions that we have for the Department of Health. And we will share the information when we learn about it. Next slide, please. And we have a poll.
Great. Thanks, Val. So I'm going to launch the poll and I'll read it out loud in case that's helpful for anyone. Okay, the first poll question. Maria was assessed by NYIAP in June 2025, but has still not enrolled in an MLTC plan. Will the new ADL test apply to her when she enrolls in an MLTC plan in November of 2025? The first option is yes, because the deadline to enroll was September 1st, 2025. The second option is no, because she was assessed since September 1st, 2024, and enrolled in a plan within 12 months of the assessment. Please take another few moments to answer.
Are we giving prizes for this, Rachel?
Oh, good question. Prize is a good pat on the back for whoever gets this right. You've been listening well to Val. But don't feel bad if you don't get it right, because you could download the slides and refresh your memory. Okay, so it looks like we have about a little over half who have answered. I'll read the question one more time in case anybody else needs another minute. The question is, Maria was assessed by NYIAP in June of 2025, but still has not enrolled in an MLTC plan. Will the new ADL test apply to her when she enrolls in an MLTC plan in November 2025? We'll give a few more seconds. Okay, I'm going to end the poll and go ahead and launch the results. 24% answered yes, because the deadline to enroll was September 1st, 2025. And 76% of people who responded answered no, because she was assessed since September 1st, 2024, and enrolled in a plan within 12 months of the assessment. Val, would you like to share the answer?
So the 76% of people were right, but I'm actually glad some people got it wrong because this is confusing. And so we want you to understand why the second choice is right. So the deadline to be assessed to enroll in a plan is not September 1st. I think that's the big takeaway here. that we really want to emphasize. We thought it would be before they issued the guidance, but we were sort of, we don't love any of this, but at least we were glad to see that the deadline to enroll in a plan is not September 1st. As long as, because Maria was assessed in June 2025, as long as she enrolls within 1 year of that, so she could even enroll June 1st, 2026, and she would still have legacy status because she was assessed before September 1st, 2025, and if she enrolls within 1 year of that assessment. So this is probably the most important takeaway for you to understand your client's rights when they go through their first reassessment after um, after September 1st. You'll know you need to think through this analysis. If someone wasn't enrolled before September 1st to see, oh, do they have legacy status? They didn't enroll as of September 1st, 2025, but they enrolled, say, in November of 2025, and let's look to see when their assessment was, and you can say, yes, they have legacy status.
Great. Thanks, Val. So now we're going to move on to a second poll. And we're going to save questions till the end. So for folks who are putting questions in the chat or who have their hands raised, if you don't mind just waiting till the end, that'd be great. Okay, so we're going to launch the second poll question, which says, Paula has been in an MLTC plan for many years and is nervous about her upcoming annual assessment in January 2026. She is afraid she will not pass the ADL test. She has a traumatic brain injury and she needs cueing and supervision with 3 ADLs and limited assistance with 1 ADL. What do you tell her? First choice is not to worry because she needs cueing and supervision with 2 or more ADLs. Second choice is not to worry because she has legacy status and is not subject to the new ADL test. Third choice is she should be worried because only people with dementia are eligible if they need cueing and supervision with 2 or more ADLs, and she does not have dementia. I see the answers pouring in. Great job, everyone. I'll read through the question one more time, but everyone's doing great. So the question is, Paula has been in an MLTC plan for many years and is nervous about her upcoming annual reassessment in January 2026. She's afraid she will not pass the ADL test. She has a traumatic brain injury and needs cueing and supervision with 3 ADLs and limited assistance with 1 ADL. What do you tell her? Go ahead and submit your answer if you haven't already. We'll give you a few more seconds. Okay, I'm going to end the poll and share the results. So 12% of people who responded said not to worry because she needs cueing and supervision with 2 or more ADLs. The majority, 81% of respondents, said not to worry because she has legacy status and it is not subject to the new ADL test. And 7% answered she should be worried because only people with dementia are eligible if they need cueing and supervision with 2 or more ADLs, and she does not have dementia. Val, can you share the answer?
Okay, well, I'm pleased to say that the 81%, the majority of people got the right answer. That she does not have to worry because she has legacy status and is not subject to the new ADL test. But let's just break that down. Because I understand why people answered the other ones, and they were put here intentionally to make a point. So the people who said, oh, she doesn't have to worry because she needs cueing and supervision with 2 or more ADLs. First of all, she didn't need to prove anything because she's been in an MLTC plan, she has legacy status, she's grandfathered in. But even if she did, queuing and supervision with 2 or more ADLs does not help somebody with a traumatic brain injury. It would only help her if she had dementia or Alzheimer's disease. So if she didn't have legacy status, she would be in trouble because she would not meet the new ADL test. Yeah, she has she could, because she only needs limited assistance, that minimum qualifier with one ADL. And because she doesn't have dementia or Alzheimer's disease, they ignore the fact that she needs queuing and supervision with 3 ADLs. Does that sound like discrimination to you? It does to us, but that's how the state is implementing this. Okay. But she doesn't have to worry because she has legacy status. Now, on the last option, which we had 7% people saying she should be worried because only people with dementia are eligible if they need queuing and supervision with 2 or more ADLs, and she does not have dementia. So that's the point I just made, that if she didn't have legacy status, yep, that would be right. But the key thing here is when you're interviewing your clients, when you're assessing their case, you want to find out how long have they been in their plan, or if they're not an MLTC or MAP plan, how long have they been getting personal care or CDPAP services? And were they still getting it as of September 1st, 2025? So, because if they are, they're grandfathered in. Now, with her being an MLTC, you also want to ask, has there been any break in your enrollment? Because that could, as the slides we've just gone over, could disrupt her legacy status, which, I mean, if she's hospitalized for something and in a nursing home. But I do want to make a point for everybody that, like, many people will pass the ADL test. Like, I think, but we're very worried about the people who won't, and we think it's a violation of their rights. But for many people will pass it. So I think, like, having legacy status or having dementia or Alzheimer's allowing you to have queuing is not going to be that important for many people, because many people need limited assistance with 3 ADLs. But we're going to go over more of, I'm not saying, oh, this is nothing by any means, but for many clients, it won't matter. But of course, our job is for the clients for whom it does matter to give them access to care.
Thanks, Val. And thanks everyone for answering. We'll now return to the slides.
Great. Okay, so now we're moving on to the people who do not have legacy status and who are first getting assessed for MLTC, MAP, Medicaid Advantage Plus, personal care, or CDPAP after September 1st. Next slide, please. So one thing that was a bit of a shock to us in reading the guidance is that this 3 ADL restriction applies to all Medicaid recipients, including children. We were really taken aback by that because we sort of assumed it was only adults, even though when you look at the statute, it doesn't say adults, so only adults. So, but that was very, very disturbing. So what entity will apply and decide if you meet the ADL test? So this is just some review from before. Many people are assessed by NYIAP for home care. Those are people who are seeking standalone personal care CDPAP from a mainstream plan or from their local DSS, or for those who are seeking MLTC, or MAP enrollment. And I want to stress that that is adults. It doesn't say, the slide doesn't say it, but NYIAP is only assessing people 18 and over. Some people do not go through NYIAP, and that includes children aged 18 and under. So, but the restrictions will apply to them, but they will be determined by their mainstream managed care plan if they are in one, or if they are not in one, the local Department of Social Services will screen for the ADL test. Now, the ADL test is not a separate document. It's all done within that assessment tool that a nurse does, whether it's a NYIAP nurse or a managed care plan nurse or the DSS nurse. They use this uniform assessment tool, and they tick the boxes of what ADLs the person needs assistance with, and at the end they just simply add up how many ADLs does a person need the required level of assistance with, and that's how people will meet it. Okay, next slide, please. So for going forward, the first thing you're going to ask, and the first thing the assessor should ask, is does the individual have legacy status? Okay, and now you've learned more about that. If so, the less restrictive 1ADL criteria applies, and cueing and prompting is enough as in terms of the level of assistance. Then the question is, what if as part of that, you're asking if they're not in a plan or receiving home care, were they assessed for home care since 9/1/2024? And can they enroll in a plan or start home care from the local DSS or their managed care plan within 1 year of that date? So this is all going to be part of your intake going forward. If not, if the assessment, let's say it's now December 2025 and you've just helped your client get Medicaid and now they're applying for home care or MLTC, so they don't have legacy status. So then, do they need limited assistance with 3 ADLs? And go back to those slides earlier that explains what limited assistance is. And if not, will their doctor certify that they have dementia or Alzheimer's disease? And if so, do they need supervisory or cueing assistance with 2 ADLs? If not, they are not eligible. If yes, the doctor has to sign a form. DOH releases new form, the 5821, that has to be signed by a medical doctor or a DO. They do not have to be a Medicaid provider to sign this form, and that has to be submitted. Of course, they don't say how to submit it. If you're doing a telehealth assessment, how do you submit it? We do not know. And the guidance says that a new form must be submitted with each annual reassessment. So apparently, DOH has news that we do not have, that there is a cure for dementia. I mean, the guidance says that they have to get the plan, NYIAP, everybody has to keep that form on file. Well, once a doctor has said you have dementia or Alzheimer's disease, I have yet to hear of anyone who no longer has those diseases. But yet a new form must be submitted with each reassessment. If they don't pass the 3 ADL test and you're relying on needing cueing or supervision with 2 ADLs. Don't forget, many people with dementia will be eligible without the form because they need limited assistance with 3 ADLs. They don't need to submit any form proving that they have dementia. This is for people who don't pass that 3 ADL test and need to show that they have dementia so that they can pass with the 2 ADL test. But if the doctor doesn't sign the form and if they don't have dementia, it doesn't matter if they need supervision or cueing, they are not eligible. All right, and the next slide just does this whole thing in sort of a different format. Some people find it easier to look at sort of a flow chart. So, but you can look at that on your own. It's the same information. Next slide, please. So now we get into denials and appeals. So if NYIAP, the New York Independent Assessor, denies MLTC or home care based on the ADLs or a managed care plan or the local district, the person has appeal rights. So if the person is 18 or over, it's going to be NYIA, the independent assessor that does the assessment. They're going to be the ones saying, you failed the ADL test. The fair hearing will be against the independent assessor. For children under 18, if they're in a managed care plan, their appeal, the ADL test will be done by that plan, and it's the plan that will say you failed the ADL test. And as in all managed care, they must exhaust their internal plan appeal. So they must do that first. And then if that's denied, request a hearing. If the child is not in managed care and they requested home care from the local DSS, then it's the DSS that says you failed the ADL test and the fair hearing is against the DSS. Next slide, please. So this slide shows you what an outcome notice looks like from the independent assessor. Unfortunately, they don't say adverse notice or outcome notice. The notice is titled Important Notice About Your Assessment. So it doesn't really flag that you lost. Care is denied. MLTC enrollment is denied. So you have to really dig in and look under the hood of the letter. But this is what we call an outcome notice. And until now, an outcome notice for someone seeking enrollment in MLTC would say you are not qualified to enroll in an MLTC and say because you do not need ADL assistance for more than 120 days. So again, that was just one ADL, right? And 120 days, it would mean because it's long term. So if you just broke your leg and you're going to recover in 30 days, you're not eligible. But now the notice will have to be amended because it has to include the ADL test. We don't know how specific the notices will be. So the first people who get notices after September 1st, we'd appreciate it if you'd share it with me or with anyone on our team so we can see what they look like. Will it say you don't meet the ADL test? Will it say you have 2 ADLs but not 3 ADLs? Will it say you need only cueing and prompting with ADLs? That doesn't count because you don't have dementia. I mean, it seems to me that a good notice should really go through all of these boxes and say it should even specify you need limited assistance with bathing and dressing, but not with anything else. So the person knows what was found and they can say, wait a minute, I need limited assistance with ambulation also. But we don't know. We don't know how detailed the notice is going to be. Next slide, please. The notices also say whether the consumer is medically stable. And this is because in the regulations for personal care and CDPAP require that eligibility is only for someone whose condition is medically stable. There is a a good statement in the MLTC policy implementing the ADL limits, and this was a welcome policy, said that plans, MLTC plans, may not deny enrollment if the independent assessor finds the person is not medically stable, unless the plan is unable to provide any other long-term services and supports that the consumer is eligible for. So, for example, private duty nursing. So this is new, and we're very glad to see that, because MLTC plans and MAP plans have private duty nursing within their service package. And if someone is not medically stable for personal care or CDPAP, the plan should be authorizing private duty nursing. So again, something to keep in mind. If someone does not have Medicaid or in that younger age group of age 18 to 21, and they do have Medicare, but they're in the voluntary enrollment group, the notice should also say whether they were determined to have a nursing facility level of care. We talked about that a little before. There's a score on the assessment tool that it must be 5 or more for them to be able to enroll in an MLTC. A score of 5 is pretty easy to meet. So if the outcome notice says MLTC enrollment is denied, the consumer has a fair hearing right to appeal against the independent assessor. But it used to be that if enrollment was denied, saying you don't need community-based long-term care for more than 120 days, you could still seek housekeeping services from the local DSS. That is no more after September 1st. Although if the assessment was done before September 1st, oh, no. As long as they apply and get services authorized within a year of the assessment, they should have legacy status. So people who have been recently assessed, even if NYIAP denies them, they might squeeze in to be able to get the 8 hours a week of housekeeping services because they're in this transition period. I know it's complicated. It's complicated for me too. Okay, next slide, please. So we talked about if the outcome notice says you're not eligible for MLTC. What if the person is in a mainstream plan asking for personal care or CDPAP? Or what if the person is seeking immediate need home care from the local Department of Social Services? What does the outcome notice say then? Then it should say whether they meet the new ADL test, whether they are medically stable, but it should not say, it should not deny services because you don't need community-based long-term care for 120 or more days, because that's only a requirement in MLTC plans and MAP plans. That's not a requirement from mainstream managed care or from DSS. We have found there's gaps in the system that NYIAP might authorize services and say the person is eligible, but the consumer can't sit around and wait for their managed care plan or their local DSS to contact them and say, hey, we understand you got an outcome notice saying you're eligible for personal care. We'd like to give you services. The consumer has to be proactive and tell their managed care plan or their DSS of that they received the outcome notice. In New York City, it's the HRA Home Care Service Program intake fax. Maybe Rachel can find that and post that in chat where they fax in the outcome notice. And if they're not, if the outcome notice says they're not eligible for personal care CDPAP, the consumer can request a fair hearing against the New York Independent Assessor. And again, we don't know what these notices, how detailed they'll be. Will they just say broadly, you don't need limited assistance with 3 ADLs, or will they really be specific? We think they should be specific, but I'm not too optimistic about that. Okay, next slide. We talked about requesting a hearing. It's the same old way. People have requested hearings for years. There's no way of continuing on these hearing requests, of course, because you're requesting a service that has never been approved. So there's no way of continuing. You can request that the hearing be expedited, and these would be appropriate hearings to request be expedited because the person needs home care. So we have a link when you download the PowerPoint. That link should work to state guidance on how to request an expedited hearing. Next slide. A poll.
Okay, great. I'm back. So this is going to be our third and final poll. So don't miss your chance to vote. Okay, so here's our third poll question. Just like last time, I'll read it out loud. Roberto went through a NYIAP assessment on September 15th, 2025, and received an outcome notice saying he is not eligible to enroll in an MLTC plan because he needs limited assistance with 2 ADLs and he does not have dementia. You can help him, 1, request a fair hearing to appeal NYIA's denial if it was incorrect based on his needs. 2, check to see if he could have legacy status if the assessment was scheduled to be conducted before September 1st, 2025 and was postponed for no fault of Roberto's. 3, check to see if he was authorized for personal care or CDPAP in the past because he could have service legacy status. Or 4, all of the above. I see the votes pouring in. I'm going to, again, one more time read the question so people have a few more seconds to answer. The question is, Roberto went through the NYIAP assessment on September 15th, 2025 and received an outcome notice saying he is not eligible to enroll in an MLTC plan because he needs limited assistance with 2 ADLs and does not have dementia. You can help him do which of the following? Okay, the answers are slowing down. I'm going to go ahead and end the poll, and we will look at the results. Okay, so 4% of people who answered responded, request a fair hearing to appeal NYIAP's denial if it was incorrect based on Roberto's needs. 4% answered, check to see if he could have legacy status if the assessment was scheduled to be conducted before September 1st, 2025 and was postponed for no fault of Roberto's. 2% said check to see if he was authorized for personal care or CDPAP in the past, because then he could have service legacy status. And 89% said all of the above. So Val, take it away. What's the correct answer?
Okay, 89% of the people were right. These are all steps that you can take. And it occurs to me we should we'll put this on a slide and because it's a good learning tool, and post it where the one now is posted and just swap it in. I mean, these are all things like a good advocate, I think, should pursue in trying to deal, especially in these assessments that are just after September 1st. I mean, it's very possible that it could be, the second one, that it was scheduled and it was postponed. That's not going to be true in 6 months, right? but it could be true now, like very soon after September 1st. And the third one could be true, that he got personal care or CDPAP in the past, and he could have service legacy status, even, um, and hopefully he has some records for it. So, it's worth asking.
Perfect. Thanks, Val. So now we're going to finish the rest of the slides. And at the end, if we have a little bit of time before 4, I'll go over a few of the questions with Val that people have posted in the question section.
Okay, well, we're
Val.
going on down to the finish line. Thank you all for hanging in. I know it's a lot. It's not my fault that it's a lot. All right, Rachel, next slide, please. All right, so some tips. All right, if you're helping people through assessments after September 1st. Next slide. All right, so even before, many people have been denied MLTC enrollment or personal care CDPAP with the independent assessor because of different systemic problems. So those will continue and then be made worse because of this ADL test. But so here are some things to look out for that have been true ever since the independent assessor took over. And some of these are from the reference guide that is used to train nurse assessors. The last one that we have that's been obtained by us is from August 2022. We're trying to get the more recent one. There's probably a more recent one. If you have it, please email it to me. But that can be downloaded online. So there's a few points from that. Next slide, please. So, tip one is to you really are going to have to prepare the client or their family member, geriatric care manager, whoever it is that they're working with for the assessment. I mean, now you have to have a plan. Okay, let's review the list of the ADLs. Which ones do we think that the consumer will meet the limited assistance criterion, which again is guided maneuvering of limbs, physical guidance, but not weight bearing. So it's more than supervision or cueing, it's more than verbal cueing, but it's less than weight bearing support. So it's subtle, and we're all going to be learning about exactly what does that mean. But if you count 3 or more, you'll want to counsel the consumer and whoever is with them at that assessment to point these out and make their case that they need limited assistance with these 3 ADLs or more. It can be more, of course. Extensive assistance, maximal, total. If you don't think that they have a chance of meeting that test, then see if they do have dementia or Alzheimer's disease and identify whether they need cueing and supervision with or more with at least 2 ADLs. And again, they have to be counseled to point this out to the assessor. But you want to help them think through which ADLs and make the case. There are many types of dementia. And some ADLs are borderline, and you'll want to really help work with the consumer and their family about making a case that they meet the criteria. So this is like a whole new world of preparation. Next slide, please. Next is something that is in the UAS-NY reference manual that tells the assessor, the nurse who's doing it, must record the person's actual level of self-care and support that they actually received during the last 3 days only before the assessment. So that's what they use to score the ADL. The manual specifically says the assessor should not record what they think the consumer should receive or what they think the ADLs, what ADLs the consumer could do for themselves. It has to be what they actually received. So really only a consumer who had help, whether paid or by family, during one of the 3 days before the assessment is found to need ADL assistance. So, for an example, and this is from a real case, Jose's daughter visits to help him bathe twice a week and physically helps him get into and out of the shower. But when the NYIAP assessor visited on Monday, the last time the daughter helped him bathe was the previous Thursday. Since this was not within the last 3 days, the assessor would mark activity did not occur, and the ADL would not be counted toward the minimum. So you get that. That's part of the preparation for the assessment, is that the client, the consumer, the family have to understand this rule and arrange their informal care or paid care accordingly, so that the nurse really assesses what help that they are getting. Another example, and this was from a fair hearing that a colleague won. Maria bathes by herself, but it is extremely risky. But because she bathes by herself, the nurse marked her as independent with bathing. And in a fair hearing, the judge said, you know, if it is really difficult for this and time consuming and dangerous for the consumer to do this task independently, then it's just misleading and false to say that they're independent with that ADL. So that's one fair hearing decision that found that, but honestly, based on the law as it's written, I don't think you're going to win on that. So I'm giving that example that a judge rejected that. And this was when there was just one ADL required. And all she needed was the ADL of bathing. And so the whole hearing was about, does she need assistance with the ADL? Imagine now how much harder it will be to prove that you need assistance with 3 ADLs, or 2 if you have dementia. So the consumer should have help with ADLs in at least one of the 3 days before the assessment is done, whether it's informal help or help by a paid help by the family. And you can look this up in the reference manual. Next slide. So, as in that example, the nurse often mislabels as independent with ADL. So, if the person has dementia or Alzheimer's disease, you point out the need for reminding and cueing to use the walker, on how to wipe themselves after toileting, and how to reminding someone to feed themselves and pick up the fork, and how to dress and wash and brush teeth, all of that. But if they don't have dementia, then I guess you're really going to be looking for contact guarding, which should qualify as limited assistance. So that's really what you're going to be drawing out. Another tip is that NYIAP will schedule all assessments to be conducted by telehealth because it's faster, and obviously the nurse doesn't have to travel. And can do many more in a day. But these inevitably miss nuances. And so if you're a borderline case and you think, look, if the person is bedbound, it's fine to do a telehealth. If they need total assistance with 3 or more ADLs. But where it's a borderline case, then I would say really think about demanding an in-person assessment, which is the consumer's right. So you can really show the layout of the apartment, how far they have to walk, why they need contact guarding to walk to the bathroom, all of that. Okay, next slide. So we've talked a lot about all this, and let's just look a little bit about are these ADL limits legal? Next slide. So as we pointed out, there's blatant discrimination based on diagnosis in these ADLs, right? Because there are many impairments that result in the consumer to need cueing and supervision with ADLs. Intellectual and developmental disabilities, or IDD, is a big one. Also, traumatic brain injuries, visual impairments. I mean, when someone becomes blind at age 90, it is much harder for them to learn, um, how to navigate than someone who may have been visually impaired since birth or at a much younger age, and they need cueing and supervision. But only people with dementia are given permission to count cueing and supervision with 2 ADLs. So that discrimination, we think, violates the Americans with Disabilities Act, violates the Medicaid law, and could cause people to be forced into nursing homes or make it harder to leave nursing homes in violation of the Americans with Disabilities Act as interpreted by the Olmstead decision. New York is also, many people don't know about Community First Choice Act or CFCO services, but New York is drawing down billions of dollars in an enhanced federal match because it's calling consumer directed services and personal care CFCO services. And to get that enhanced match, they're required to provide cueing as well as physical assistance with ADLs and IADLs for those who have a nursing home level of care. So we talked about this a little before. There's an MFLOC score, nursing facility level of care score, on every single assessment. If that's 5 or more, that person is entitled to this assistance with ADLs and IADLs, regardless of whether they pass the ADL test. But New York has no mechanism for providing those services. So we think that violates the FCO. Next slide, please. Another legal claim is that for children under age 18, that there are special requirements in the law for children. They're called the EPSDT requirements, which stands for early and periodic screening, diagnosis, and treatment. And that law, which Rachel, who's helping with this webinar, taught us about in FLIRP, does not allow hard limits on services for children and requires an individualized determination. So children might have specific claims based on violations of that law if they are denied for failing to meet the ADL test. There's been a bill kicking around Albany for a couple of years. It keeps getting renumbered to repeal this. But especially now, given the Trump big, horrible bill on Reconciliation Act, which is going to take billions from New York in federal funds, this has basically no chance of passing. Next slide. And CMS gave permission to impose the ADL thresholds. The state submitted a state plan amendment, and CMS said, even this is under the Biden CMS, said they didn't need to amend the state plan, that the state can change its definition of medical necessity. And the state requested amendment of the waiver that governs the MLTC program. And in that letter, CMS, again under Biden, did say that the state must ensure that the eligibility standards do not discriminate based on disability. So they said that, but they allowed it to go in effect. But that at least flags an acknowledgement that CMS could think that these violate, that discriminate based on disability. All right, next slide, please. And then we're ready for questions. So is it smart, even apart from whether it's illegal? So the housekeeping program, giving 8 hours a week of services has been an important preventive service for as long as the personal care program and CDPAP have existed, because it prevents people from falling, having other accidents, uh, being dehydrated, not eating properly, right? Because someone is doing your shopping and some meal prep. Even 8 hours a week could make a big difference in preventing hospital stays and nursing home stays. The other thing is that there's an ISEP program, which is a non-Medicaid home care program run by the State Office of the Aging, which already has long waiting lists. And if you have full Medicaid, you're not eligible for that ISEP program. So, but people with the spend down could be eligible for that. And if they pass the ADL test, they're going to join the waiting list for ISEP and put more pressure on that program. So I think, is that it, Rachel? These are some of the links that if you're not an attorney or paralegal who does these hearings, that the third bullet is to an article that lists some nonprofits in New York State that help with home care and manage long-term care cases. And we have our FLRP email address. So we have time for just a few questions. Oh, but the all important request for donations. This webinar was free. It's really not free. It costs money to do this. A lot of staff resources. So we would really appreciate your donation, especially to anyone in private practice, geriatric care managers, private attorneys. We really appreciate it. We're doing something that the state should be doing. The state should be educating the public about these major changes, and they are not. So we're very proud that NYLAG has stepped up to do this, and we hope that you support us. All right, Rachel, a few questions, right?
That's correct. Just so everyone knows, we of course don't have time for all of the questions. We've gotten 41 really great questions. I will share all of these with Val. We'll do our best to answer them, maybe on the New York Health Access article. And the article has been posted in the chat. I will start with a few questions that seem to have a similar theme. One question is, Val, will the new change to the ADL requirement apply to NHTD waiver services, medical transportation appointments, or services like structured social adult daycare?
Great questions. No, it only applies to personal care and CDPAP and enrollment in MLTC plan or MAP plan. But people in the nursing home transition and diversion waiver or the TBI waiver often receive CDPAP or personal care services as their sort of base level service to help them with their ADLs. And then the NHTD or TBI waiver services sort of wrap around them, those special services. So they will still be affected by this because their access to personal care or CDPAP will be affected, but not transportation, not whatever the adult daycare, whatever else was there. It's only personal care, CDPAP, MLTC, and MAP.
Great, thanks, Val. Does simply being in one of the waivers, like the NHTD waiver, TBI waiver, OPWDD waiver, or a children's waiver, give you a legacy status?
No, it does not. You must meet the criteria because that would have meant they were exempt. from the ADL restrictions. There is no exemption in the law. There's only one exemption in the law, which says people with dementia or Alzheimer's disease have a lower threshold of ADL need. They can qualify with just queuing with 2 ADLs instead of limited assistance with 3 ADLs. But it is silent on everybody else in those waivers that you listed. So no, absolutely not. Very important takeaway.
Thanks, Val. If you were assessed now and you find out that you were denied, and then 120 days later, you reapply and are reassessed, which date of assessment will be used? What's the date?
That's a good question. I mean, the way that they define legacy status is that you have to be assessed and then start getting services within a year. So when you say you're denied, like maybe there's some room to look at that denial and maybe appeal that, but you'd have to do it quickly because you have to, let's say you were denied because of the problems we've seen that in NYIA assessments, them saying you're independent, right? Them saying you didn't bathe in the last 3 days, therefore you didn't have help, and therefore we're not going to count the bathing ADL. So let's say you appeal that and get it done. If that's the assessment by which you start getting services, you just have to start getting services within 12 months of that assessment. But the question sort of implies like a related question of, well, what if you just get a new assessment that's better and that new assessment is done after September 1st? I think we don't know the answer to that question yet.
Thanks, Val. Is it possible that someone might lose their legacy status due to involuntary disenrollment as a result of an issue with a Medicaid renewal processing?
That's a great question, and I didn't list that, but yes, it seems to be that one could be, because we know that services, I mean, plan enrollment gets disrupted if you have a hiccup in your Medicaid renewal and you're disenrolled from an MLTC plan or a MAP plan. And if there's more than a month gap in re-enrolling, which there can easily be. If there's not a month gap, then it's not a problem. If there is a month gap, I would then go to their slide about, but you still have service legacy status. And with that, you're entitled because the statute for personal care and CDPAP says if you were initially authorized for those services before the effective date, you have legacy status. So I think it would be a pivot from focusing on MLTC to looking at how can you access those services. But that really is going to require the state to issue guidance because right now, the only way for an adult dual eligible to get personal care or CDPAP is through an MLTC plan. But if they lose their plan legacy status, there's going to have to be an alternate way for them to get CDPAP or personal care. Or they'll have to carve out an exception. That's one of the things that policies that we are advocating for.
Thanks, Val. If someone is incorrectly disenrolled and then wins a fair hearing on that disenrollment, can they maintain their legacy status?
So that's a great question. You know, none of that's in the guidance. These are all things that are going to percolate and, over time be fleshed out with someone might have to argue that at a fair hearing or go to DOH and say, look, this is only fair. They won their hearing. But these are all going to be a fight, either on a policy level or a fair hearing level or both.
Thanks, Val. There are quite a few more questions, but I think that we might end it here. We're 2 minutes before 4 o'clock. So what we'll do with the last 2 minutes is just one more time, I'm going to paste all of these links into the chat. Again, I've copied all of the questions that we've received, and we'll do our best to try to answer as many as are relevant in the article. Once again, here is a copy of the PowerPoint slides. I'm also putting into the chat the New York Health Access article about the ADL restrictions, our website, New York Health Access, our FLIRP newsletter, where you can stay up to date on articles that we're posting and webinars that we're hosting. And again, the link to donate. If you or someone you know can afford to donate, it helps us keep all of our work, the direct representation, the community education, the policy advocacy, helps keep it free and continuing. So thank you everyone so much for joining us, and we hope that you have a great day.
Thanks, everyone.
Thanks.